For over 4 months, Watergate has dominated the news media. During the past 3 months, the 3 major networks have devoted an average of over 22 hours of television time each week to this subject. The Senate committee has heard over 2 million words of testimony. This investigation began as an effort to discover the facts about the break-in and bugging of the Democratic National Headquarters and other campaign abuses. But as the weeks have gone by, it has become clear that both the hearings themselves and some of the commentaries on them have become increasingly absorbed in an effort to implicate the president personally.
In the summer of 1973, the Watergate Special Selection Committee held its hearings. It is chaired by Democratic Senator Sam Ervin and Republican Senator Howard Baker. The senators know, as do all Americans, that on June 17, 1972, during the presidential campaign, 5 burglars were caught breaking into the Democratic Party headquarters in the Watergate Hotel in Washington, D.C. The FBI investigation concluded that 2 men, Gordon Liddy and Howard Hunt, had supervised the break-in and had also been previously employed by the White House.
Following orders without question, it never occurred to me to question if you will, the legality, the propriety of anything that might be ordered by the Attorney General of the United States.
Despite Watergate, President Nixon won a landslide re-election. Yet doubts spread throughout Washington about the White House involvement in the burglary. The Senate committee has been appointed to investigate. The first hearings proved that others from the White House were involved. The Attorney General himself had covered up the break-in.
In 1972, where I still believe that the most important thing to this country was the re-election of Richard Nixon.
The head of the FBI destroyed key documents related to these operations.
I distinctly recall Mr. Dean saying that these files were political dynamite and clearly should not see the light of day.
All witnesses who testified declared they acted on their own, that is, until John Dean, a Nixon staff member, involved the president.
I told the president that I hoped that my going to the prosecutors and telling the truth would not result in impeachment of the president. He jokingly said, "I certainly hope so also."
This really is, and I don't mean to be melodramatic, but this is really a terribly important moment in history, as you know. This meeting in the afternoon in the Oval Office in Washington on September 15th, 1972, and you were there, the president was there, and Mr. Haldeman.
Mr. Haldeman was there.
What was the president's demeanor? What was his attitude? What was the expression on his face, the quality of his voice?
Well, as I said, when I walked in, it was very warm, very cordial. They were smiling, they were happy, they were relaxed. The president, as I think I said earlier this morning, was about to go somewhere, and I think that actually was delaying his departure to have this conversation with me. The fact that I had not been in to see the president, other than on a rather mechanical activity before that on dealing with his testamentary papers, indicated so clearly that Haldeman had thought that the president should compliment me for my handling of this matter, and that was one of the reasons I'd probably been called over, and the president had done it at Mr. Haldeman's request.
All right. Now, tell us about as you started to say before I interrupted you, the status of the case.
All right. He was interested in knowing if it was likely. Well, let me before I go on to that, let me say something else that I recall. When we talked about the fact that the indictments had been handed down, at some point, and after the compliment, I told him at that point that we had managed, that the matter had been contained. It had not come into the White House. I didn't say that. I said it had been contained.
Once again, is a terribly important area of inquiry. So let me interrupt you again and take you over it one more time. That you told the President, I don't think it can continue to be contained.
That is correct.
Are those close to your exact words?
That's very close to my words, because I had told him it had been contained to that point, and I wasn't sure that it would be contained indefinitely.
What was his reaction to that?
As I say, I don't recall any particular reaction.
Committee counsel will question the witness.
Myself.
Well, all right, taking that into the context, giving such, as I was beginning to state, such a massive cover-up operation that was underway, with the approval and with the direction at times of Mr. Haldeman, Mr. Ehrlichman, Mr. Mitchell, do you have an opinion, and I'm asking at this point, and just an opinion, as to whether the President would have been informed of this cover-up operation from its inception?
Mr. Dash, I think it's unfair to ask me opinions. I can surmise the way I know the White House operated. I'll say this, that in my statement, I indicated that I had reached a conclusion in my own mind when I went to the Attorney General, for example, that this thing might well go right to the President. I would say that that evidence is an opinion, that I was concerned that it did, knowing how the White House operated, knowing how the reporting of information went up to the President.
Well, the question is put to you just on the basis of your knowledge, your intimate knowledge, I take it, of how the White House operated and what Mr. Haldeman's relationship with the President was, as you've already testified. But actually, according to your own statement, in fact, you learned firsthand, did you not, that the President did know of the cover-up when you met with him on September 15, 1972, the day the indictments came down, cutting off the involvement at Liddy. questions. John Ehrlichman.
Raise your right hand. You swear the evidence that you should give to the Senate Select Committee on Presidential Campaign Activities should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Ehrlichman, were you assigned a role to create in the White House a capability for intelligence gathering at any time?
I don't know quite what you're getting at. If you're getting at the special unit and the problems of leaks.
I don't know why you have to find out what I'm getting at if you just answer my question as I ask it.
It's an obscure question to me.
No, it's a simple question. If the answer is no, say no. If the answer is yes, say yes.
Would you restate the question for me, please?
I said, did there come a time when you were asked to develop a capability in the White House for intelligence gathering?
Intelligence gathering. The answer would be no.
All right. Now, you were trying to seek what I was getting at. Were you ever asked to set up a special unit in the White House for the purpose of determining whether certain leaks had occurred in major national security areas?
I was.
And you knew what the unit was to do?
Yes.
All right, what was the unit to do?
The unit, as originally conceived, was to stimulate the various departments and agencies to do a better job of controlling leaks and the theft or other exposure of national security secrets from within their departments. It was a group which was to bring to account, so to speak, the various security offices of the Departments of Defense and State and Justice and CIA to get them to do a better job.
And therefore, this unit was to gather facts if there was a leak or to act as a deterrent, I take it, to prevent leaks.
No, there would have been no need to gather facts under that concept, except to know that there had been an occurrence. But to require vigorous and very active effort on the part of the responsible people in the departments and agencies to find out who was responsible and how it happened and make sure it couldn't happen again.
Now, isn't that getting facts? If you were seeking to find out who was responsible and the unit was looking for it, wouldn't you be wanting to get facts?
Well, see, you were asking me about intelligence and
no,
I
you're jumping again ahead of me. I didn't say intelligence, I said facts.
All right, the facts in that sense, but limited to that.
Right. Now, would you say some people who go for seek facts in an investigative way can also say they seek intelligence?
Well, but you see, what I'm trying to say to you is that as originally set up and conceived, this was not an investigative unit in the sense that your question implies. It was far more a group that was established for the purpose of getting the security people in the departments and agencies to do a better job of their job.
Was it ever called or was it ever referred to as an investigative unit?
Subsequently it was, because it became an investigative unit subsequently.
So there came a time when you were administering an investigative unit?
Yes, in a literal sense, that's true.
In a literal sense?
Yes, sir.
But not in an actual sense?
Well, here I am dueling with a professor.
No, I'm not dueling with you. I'm just trying to get a...
Professor, if you say actual, it's actual.
Now, is this the Special Investigations Unit that later began to be known popularly as the Plumbers?
Yes.
When did that occur?
That it became known as that?
Yes.
I don't know. That was never a term that was familiar to me until it was used in the press.
Now, I take it that all of these activities did, I think, at least show, even though some of them may have been abortive, a continued interest in the White House to improve intelligence gathering so far as internal security matters? I think you've answered affirmatively that there was a feeling for a need for this, and that these activities indicated that some efforts were going on in order to meet this need.
You've just scrambled the eggs, Mr. Dash. These are all very separate subjects. And you've taken me over a span of 3 years, and you've taken me into a lot of different subjects, some of which were vital national security, some of which were pure politics, some of which were really a need in our law enforcement system in the country for coordination. You've dumped them all in a hat and stirred them around and said, see what these bad fellows in the White House are up to.
I said nothing about bad fellows in the White House, and I asked you earlier whether or not you were aware of a need that the people in the White House, Mr. Haldeman and perhaps yourself, felt for an improved need for intelligence gathering.
As an isolated subject, you're absolutely right.
And there was such a need.
There's no question about it in my mind.
Mr. Hunt's safe was opened in the evening of June 19th, according to the testimony we received. And Mr. Dean met with you on June 21st. Mr. Dean has testified that prior to that meeting, he had examined the contents of the safe, which were placed in his office. Now, Mr. Dean has testified, and whether it was on this day when he reported to you on the contents or at a later day, that when he told you about the contents with regard to the briefcase, which apparently had some electronic equipment in it, that you said or told him to deep six the contents. Now, did you tell him to deep six the contents when he gave you a description of the contents of the safe?
Well, I testified in response to Senator Gurney's question on that. In point of fact, Mr. Dash, what Mr. Dean testified to here, you're confusing one of his press leaks with his testimony, I think. He testified here that I told him to get rid of the briefcase, not the contents. You probably read in one of the news magazines the other version, but the fact is that I never gave him any suggestion or direction to do either one.
I think Mr. Dean did testify that to deep six the briefcase and certainly not take the contents out before he deep sixed it. But you say you never gave him that instruction.
No, sir.
And do you use that term, deep six?
Do I use it?
Yes.
Well, I've used it quite a bit since it was suggested to me.
Prior to that time.
Prior to that, I don't think that's a familiar part of my lexicon.
Well, apparently Mr. Dean didn't seem to understand either what you meant, and when asked, his testimony, that you mentioned the fact that he goes over the bridge and he could drop it into the water. Do you recall that testimony?
No, I recall some testimony. Do I recall the testimony?
Yes.
Yes, I recall hearing him say that here.
Now, do you recall having told him that?
No, I didn't tell him that. I do recall a conversation with Mr. Dean about the river, because just at this time, Mr. Dean's house was in the process of being flooded by the Potomac. And we had quite a bit of discussion about the fact that he was away from work several days, sandbagging his house and moving the furniture and so on. And we were discussing that in the context of his having held this material from the FBI for what he was concerned might be considered to be an inordinate period of time.
And so he may have got mixed up your question about his house and the river with the contents? Is that your suggestion?
No. I don't think Mr. Dean's at all mixed up. I think he knows exactly what he's trying to do.
But it's quite obvious that since the safe had not been opened yet, taking what you say to be true, Dean certainly wouldn't be claiming that you were telling him to deep six something on that day.
Mr. Dash, Mr. Dean has had so many versions of these stories that I don't think you can assume that any one of these would be more reasonable than any other. I appreciate your situation vis-a-vis Mr. Dean and the committee, but I think you have to recognize that there are many, many versions of this story that have been floated to you and the prosecutor, and all in the interest of immunity.
I was at the White House as a deputy assistant to the president from the first day of the Nixon administration, January 21, 1969, until noon of March 14, 1973.
Mr. Butterfield, are you aware of the installation of any listening devices in the Oval Office of the President?
I was aware of listening devices. Yes, sir.
One word, therefore, to reconstruct the conversations at any particular date. What would be the best way to reconstruct those conversations, Mr. Butterfield, in the President's Oval Office?
Well, in the obvious manner, Mr. Dash, to obtain the tape and play it.
I have no further questions, Mr. Chairman.
Been so clear, I have no question.
The year 1972, the year in which the president would be up for re-election, we also approached the critical time of culmination, or at least of major steps towards the accomplishment of several of the president's major goals: the end of the war in Vietnam, the opening of relations with the People's Republic of China, the achievement of agreements to limit nuclear arms, and the other agreements with the Soviet Union. President Nixon's concentration was, of course, on these extremely important matters. I was in meetings with the president all afternoon on September 15, 1972. At the end of the afternoon, the president had John Dean come in. Mr. Dean drew the erroneous conclusion that the president was fully knowledgeable of the cover-up at the time of the March 13th meeting, in the sense, one, of being aware that money had been paid for silence, and that, two, the money demands could reach $1 million, and that the president said that was no problem. He drew his conclusion from a hypothetical discussion of questions, since the president told me later that he had no intention to do anything whatever about money and had no knowledge of the so-called cover-up. As was the case with all meetings in the Oval Office when the president was there, this meeting with Mr. Dean was recorded. At the president's request, I recently reviewed the recording of that meeting, at which I was present throughout, in order to report on its contents to the president. I should interject here that I also reviewed the recording of the March 21st meeting of the president, Mr. Dean, and myself for the same purpose.
The president consented for you to put in your version of these, your interpretation of these tapes in your statement.
The president authorized me to testify as to my recollection of meetings in which I was present.
Did the president give you consent to put your interpretation of these two tapes in your statement? That's my question.
No, sir, not. He specifically authorized me to give my recollection, obviously aided by having listened to the tapes.
Wasn't there a little bit of collaboration between you and attorneys for the White House in the preparation of this statement?
I don't know what you mean, Mr. Chairman.
Collaboration, don't you know what the word collaboration means?
Yes, sir, but I don't know what you mean by collaboration between me and...
Didn't they know what was in your statement?
Pardon me?
Didn't the attorneys for the president know what was in your statement?
No, sir.
Well, will you please tell me why they put this third paragraph in this letter of July the 30th, 1973, that if asked to testify as to facts which he learned about meetings or portions of meetings which he did not attend, but of which he learned solely by listening to a tape recording of such meeting, the president has requested you inform the committee that Mr. Haldeman has been instructed by the president to decline to testify to such matters, and that the president in so instructing Mr. Haldeman is doing so pursuant to the constitutional doctrine of separation of powers. Mr. Chairman, wait, I'm asking no witness a question, Mr. Wilson. This is no question law. I'm asking you how the attorneys for the president, why they wrote such a letter as this and gave it to your lawyer instead of this committee.
I don't know how they knew it. I represented to my attorneys my concern that in preparing my statement, I was obviously of necessity dealing with matters that covered events, the knowledge of which I had as a result of listening to the tapes. And I asked my attorneys to ascertain for me what requirements I would be under in terms of separation of powers restrictions as to my testimony in that regard.
That here, as the President of the United States stated on the 23rd day of July, that in effect that he had sole control of the tapes, that none would be public. Here is the man next to him in the White House appears before this committee this week and puts his interpretation and evidence, makes it public, and it appears here there's been conferences between his counsel and counsel for the White House in which a model procedure would be devised whereby the White House counsel, instead of preparing and making the objection themselves as would be the normal thing, whereby they give the letter to the counsel for the witness.
Well, Mr. Chairman,
the committee.
Mr. Chairman, may I?
So I would say that the clear indication is that the White House's counsel wanted Mr. Haldeman to reveal his interpretation of the tapes to the public.
Yes.
Yeah. Well, my time's up. 10 minutes up.
Well, how do you, first of all, let me say this, that as I read your statement, every one of the actions which you indicate to me was a reaction rather than an action, a reaction to this committee or to the prosecutor or to what other arm of government is moving forward. But how do you jive making a statement before the committee on the one hand, or to me, that you advocated putting out the truth, getting out a complete statement, with the statements you make to Senator Inouye, where you go ahead and said it was not contemplated the existence of these tapes would ever be known?
Well, Senator,
certainly, is there a greater repository of the truth in this matter than these particular tapes?
Yes, sir, I think there is. I think there's a much greater repository in the testimony of first-hand witnesses. The tapes relate only to several meetings with the president. The problems of the Watergate and the things that we were trying to get out over a long period of time until March 21st, or if you want to go back to February 27th, didn't relate to meetings with the president at all. And I think that the facts need to be brought out and will be brought out, are being brought out, and I don't think that in that connection the tapes are the essential matter at all.
But who's going to do this? Who's going to bring these facts out? That's the essence of my question to you. Is the president going to bring the facts out?
I would think that the place ultimately that the facts will be brought out and the appropriate action taken with regard to those facts is through the judicial process, which I have full confidence in and feel is the proper place to deal with criminal acts.
The best review maybe exactly what that track record consists of. The administration, the Attorney General of the United States, in whose office matters are discussed, which matters come to your attention, and which matters should be can be categorized as representing integrity, intelligence, initiatives. The Secretary of Commerce, again, there's associations with the committee to re-elect the president, there's associations with his administration of bad information. And I've gone down and I can continue to list the names of those that appeared before this committee. But, Mr. Haley, I think that in light of the facts that are coming out, you and I would agree that this went far beyond just a few men breaking into the Watergate. but rather it's revealed. It's revealed the situation both within the committee at the President and within the White House, whereupon everything that is touched was prohibited. Thus, will not in any way shape or form allegation or contention. There is no way that any man in this country can make and establish the case that everything in the White House and everything the White House touched was prohibited. And I think that does a grave disservice to this country and even the state. And I apologize immediately for having this idea, but that is not a bigger because you touched off a spot that I should have reached and responded with a little more patience and care. But it's just a thing that is not true, and it's a tragic thing that anybody could even think that it might be true. Well, I say this every day as I sit here, and these people come before us. And I want to say this, that the real problem is that this was a disservice to the country. There has always been far too broad a definition.
Mr. Haldeman?
Yes, sir.
Mr. Dean testified he had a talk with the President on the 13th of March. Were you present at that time?
I do not recall being present in that meeting, but the President's log does show that I was in for the first 12 minutes of it.
Yes.
Or for 12 minutes at the start of at the
Well, you don't
part of
know, then you haven't read the tape of that meeting.
No, sir.
And you don't know what Mr. Dean said during the time you were not present.
No, sir, and I don't recall anything he said during the time I was present.
Let's see. He told him that Hunt was attempting to get $120,000 more by blackmail, and Hunt threatened that if he didn't get the $120,000, that he would tell the seamy things he had done for Ehrlichman.
Yes, sir.
And then the President got to discussing with him how much it would take to satisfy the demands of the blackmailers.
Yes, sir.
And he said $1 million. I suggested that figure.
He said it could go to $1 million, over a period of years, could go to $1 million, yes.
The tape said that the President said that was no problem raising the $1 million.
Well, I should put that the way it really came, Mr. Chairman, which was that Dean said, when the President said, how much money are you talking about here? And Dean said, over a period of years, probably $1 million. But it would be very hard, or it is very hard to raise that money. And the President said, it's not hard to raise it. We can raise $1 million, and then got into the questions of in the one case before I came into the meeting, making the statement, but it would be wrong, and in other exploration of this, getting into trying to find out what Dean was talking about in terms of the $1 million.
Can you point, do you know, are you familiar with the testimony Dean gave about his conversations on the 13th and the 21st of March with the President?
I'm generally familiar with it, yes.
Well, this tape corroborates virtually everything he said, except that he said that the President could be, that the President said there'd be no difficulty about raising the money, and you say the only difference of the tape is that the President also added, but that would be wrong.
And there was considerable other discussion about what you do, what Dean would recommend, what should be done, what this process is, and this sort of thing. It was a very.
Now, can you point out any other differences except that about the President saying that, but that would be wrong, and what Dean testified?
Yes, I think that the difference is in the appearance in the Dean testimony, at least as I would understand it, that Dean said it will take $1 million, and the President said that's no problem, and that was the end of the matter. And that was not the end of the matter.
Well,
and I think that's a terribly important difference, Mr. Chairman.
The original tape would be about the best way to determine whether what Dean said or whether your version is right, wouldn't it?
I guess so, yes.
Yeah. Mr. Haldeman,
what I want to point out to you is that one statement in your addendum seems to me to be of extraordinary importance, and I want to test the accuracy of your recollection and the quality of your note-taking from those tapes. I'm referring to the third to the last sentence. On page 2, the President said, there is no problem in raising $1 million. We can do that, but it would be wrong. Now, if the period were to follow after we can do that, it would be a most damning statement. If, in fact, the tapes clearly show, he said, but it would be wrong, it's an entirely different context. Now, how sure are you, Mr. Haldeman, that those tapes, in fact, say that?
I'm absolutely positive that the tape...
Did you hear it with your own voice?
Yeah, with my own ears, yes.
I mean, with your own ears? Was there any distortion in the quality of the tape in that respect?
No, I don't believe so.
Mr. Haldeman, my final question is a follow-on from that. Do you have any idea whether or not other witnesses who were present at other presidential conversations that relate to the mandate of this committee to inquire might also be entitled to hear those tapes as they relate to their conversations in order to refresh their recollection?
I don't know, Senator, but it is my understanding that no one would. First place, I don't think anybody that has appeared or will appear before this committee knew of the existence of the tapes.
What about John Dean? He knows now.
Oh, he knows now.
Do you have any idea that Mr. Dean would be permitted to go to the White House and listen to those tapes?
No, sir. It's my understanding that no one has been or will be.
Is the rationale for your utilization of them that it's an aid to the refreshing of your recollection for reporting to the President as a former staff member?
Yes.
Wouldn't that precisely exact same situation apply to John Dean?
Not at this point in time, no.
Would you be agreeable, Mr. Haldeman, if it could be negotiated otherwise, would you be agreeable personally, as far as you're concerned, would you be agreeable to bringing those tapes up here, those two tapes, and playing them?
Well, Senator, you're asking me to take a position on a legal issue contrary to the position that the White House is taking.
You're perfectly free to confer with your counsel if you wish. I'm not asking, will you ask the President to do it? I'm not asking you if you think we violate the doctrine of separation of powers. I'm simply saying, would Bob Haldeman, a witness before this committee, be agreeable as an individual, if we can otherwise procure the tapes, to them being brought here and being played in public?
Well, having been advised by counsel that in their opinion I'm not creating a legal problem by the answer that I would give and that I would want to give without even talking to counsel, is that I would welcome that opportunity because they would confirm what I've told you.
The committee has received, at least I have received as chairman of the committee, a letter from the White House dated July the 25th, 1973. Dear Mr. Chairman, White House counsel have received on my behalf the two subpoenas issued by you on behalf of the Select Committee on July the 23rd. One of these calls on me to furnish to the Select Committee recordings of 5 meetings between Mr. John Dean and myself. For the reasons stated to you in my letters of July the 6th and July the 23rd, I must respectfully refuse to produce these recordings. I cannot and will not consent to giving any investigatory body private presidential papers. To the extent that I have custody of other documents or information relevant to the work of the Select Committee, and that can properly be made public, I will be glad to make these available in response to specific requests. Sincerely, Richard Nixon.
Chairman, let me state a motion. Since there is no objection to proceeding.
Litigation is essential if we are to determine whether the President is above the law and whether the President is immune from all of the duties and responsibilities in matters of this kind which devolve upon all the other mortals who dwell in this land.
President, could you tell us your recollection of what you told John Dean on March 21 on the subject of raising funds for the Watergate defendants?
My reaction, very briefly, was this. I said, as you look at this, I said, isn't it quite obvious first that if it is going to have any chance to succeed, that these individuals aren't going to sit there in jail for 4 years, they're going to have clemency. Isn't that correct? He said, yes. I said, we can't give clemency. He agreed. Then I went to another point. I said, the second point is that, isn't it also quite obvious, as far as this is concerned, that while we could raise the money, and he indicated in answer to my question that it would probably take $1 million over 4 years to take care of this defendant and others on this kind of a basis. The problem was, how do you get the money to them? And also, how do you get around the problem of clemency? Because they're not going to stay in jail simply because their families are being taken care of. And so that was why I concluded, as Mr. Haldeman recalls perhaps and did testify very effectively, one, when I said, John, it's wrong, it won't work, we can't give clemency, and we've got to get this story out.
I would say these people are going to cost $1 million over the next few years.
You, on the money, if you need the money, I mean, you can get the money.
Well, I think that's where...
What I mean is, you can get $1 million if you can get it in cash. I know where it can be gotten. I mean, it's not easy, but it can be done. But the question is, who the hell would handle it?
That's right.
I shall resign the presidency effective at noon tomorrow. Vice President Ford will be sworn in as president at that hour in this office.
Thank you.
You are here to say goodbye to us, and we don't have a good word for it in English. The best is au revoir. We'll see you again. I'm proud of this cabinet. I'm proud of all the members who have served in our cabinet. I'm proud of our sub-cabinet. I'm proud of our White House staff. You know, I should have been by your offices and shaken hands, and I'd love to have talked to you and found out how to run the world. Everybody wants to tell the president what to do. Cause bigger than yourself. It's the cause of making this the greatest nation in the world, the leader of the world. We leave proud of the people who have stood by us and worked for us and served this country.